Good evening, all of you. I hope everyone is doing good. Today, we are going to revise one topic that is Indian Union and its territories. I took this topic from GS to UPSC syllabus. Let's try and understand. There is no need to focus on anything. Just if you can close your eyes, just close your eyes and try to listen whatever I'm saying. This type of habit will definitely help you, and it will also increase your concentration levels as well. Just try and understand whatever I'm saying. So, Article 1 to Article 4 under Part 1 of the Constitution deal with the Union and its territory. The constitutional provisions under this part as follows. Article 1, which deals with name and territory of the Union. Article 2, admission or establishment of new states. Article 3, formation of new states and alternation of areas, boundaries, or names of existing states. Article 4 deals with laws made under Article 2 and 3 to provide for the amendment of the first and the fourth schedules and supplemental, incidental, and consequential matters. So, name and territory of the Union. So, which is the Article first one of the Indian Constitution. The Article 1 of Constitution mentions the following. India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified in the first schedule. The territory of India shall comprise the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. So, name of the country. In the Constant Assembly, no unanimity could be reached with regard to the name of the country. Some members suggested the traditional name, that is Bharat, while others advocated the modern name, that is India. Hence, the Constant Assembly had to adopt a mix of both. India, that is Bharat, that's how our country name is India, that is Bharat, and Union of States. India has been described as a union, although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of States has been preferred to Federation of States for two reasons. First one is no agreement. The Indian Federation is not the result of any agreement among the states. And second reason is no right to secede. The states have no right to secede from the federation. These are the two reasons. So, and type of polity in India. India is not a purely federal state. It has been divided into different states only for the convenience of administration, but no state can separate itself from the union. The federation is a union because of its indestructible nature. No state has the right to separate itself from the Indian Union. The constitutional makers had divided the country into governable units that are states and union territories to ensure better governance and for providing accommodative space for our multi ethnic and multicultural population. So, it must be noted that the term territory of India is a wider expression than Union of India. Union of India. All the states in India form the part of Union of India. Territory of India. Territory of India includes not only the states but also union territories and territories that may be acquired by the government of India at any future time. So this is all about name and territory of the nation. And coming to Article 2 of the Indian Constitution, which deals with admission or establishment of new states. Let's try and understand Article 2. The Article 2 empowers the Parliament to add or establish new states in the Union of India on such terms and conditions as it thinks fit. So, power of Parliament is the terms and conditions of such addition or establishment are decided by the Parliament. two powers which are given to the parliament under the article are, so first one is admit new states. Power to admit new states in the Union of India, that is, for example, admission of states which are already in existence. So that is the first power. And coming to second power, establish new states. Power to establish new states, that is, states which were not in existence before. So what is the scope of it? This article relates to admission or establishment of states which are not part of the Union of India. For example, Sikkim, which was included in India in 1935, it was no part of India before this. And this is all about Article 2 of the Constitution. And coming to Article 3 of the Indian Constitution, so formation of new states and alternation of areas, boundaries, or names of existing states. Under this article, the Parliament has been giving following powers. So, what are the powers? Power of Parliament. Parliament has been given the following powers under the article. First one is new state. The Parliament can create new states out of existing states. This can be done by separation of territory from any state or by merging two or more states or part of states or by uniting territory to a part of any state. So examples like creation of Telangana out of Andhra Pradesh, Uttarakhand out of Uttar Pradesh, Punjab state by merging Patiala and East Punjab States Union, etc. So what is the area? Under the under the act, Parliament can increase or diminish the area of any state. And the next one is boundaries. Parliament can alter the boundaries of any state. And coming to name, Parliament has the power to alter the name of the state. For instance, the name of Madras state was changed to Tamil Nadu in 1969. So there are two special conditions that have to be fulfilled before Parliament decides to create new states, alter areas or boundaries of existing states. So prior recommendation. This bill can only be introduced in Parliament with prior recommendation of the President. So, what is the state legislature view here? The President, before recommending this bill to the Parliament, has to refer the bill to the concerned state's legislature so that the state can express its views on the bill. And the power of the state legislature are limited in case of the bill, that is, because unitary feature of the Constitution. And non-binding, states' views are not binding, and the President or the Parliament can choose to ignore the state's suggestions. And no reference for new changes. If new changes are made in the bill, it is not necessary to refer that bill to the concerned state again for its views. And provision in case of union territories, if the bill is related to a union territory with a state legislature such as Delhi, Puducherry and Jammu and Kashmir, no reference is needed to be made to that legislature for its views on the bill. And what is the scope of it? The Parliament, using powers under this article, can redraw the political map of India. It means that the states in the Union of India are not guaranteed territorial integrity or a continued existence by the Constitution. This is the reason why the Indian Union is described as indestructible union of the destructible states. So this is all about Article 3 of the Constitution. And coming to Article 4 of the Indian Constitution, laws made under Article 2 and 3 provide for the amendment of the first and fourth schedules and supplemental, incidental and consequential matters. There are two parts of this article. Amendment to the first and fourth schedule, that is, any law which contains provisions under Article 2 or Article 3 shall contain provisions for the amendment of the first schedule. That deals with names of states and duties and their territorial jurisdiction. And the fourth schedule, which deals with allocation of seats in the Rajya Sabha to states and UTs, which may be necessary to give effect to the provisions of the law. So that is the first one. And second part is Article 368 is not applicable. No such law made under Article 2 and 3 shall be considered as an amendment under Article 368. So, quick revision articles. So, Article 2 permits the Parliament by law for admission or establishment of new states. Article 3 deals with permits the Parliament by law formation of new states and alternation of areas, boundaries and names of existing states. And Article 4, which deals with laws made under Article 2 and 3 are not deemed to be an amendment of the Constitution under Article 368 of Indian Constitution. So, evolution of states and union territories, col- colonial position. So, territorial extent of British rule in India. The British conquered various territories during their stay in India. These territories included many of the states of India and other neighboring territories of India, that is Pakistan and Bangladesh. Mountbatten Plan. As per Lord Mountbatten's plan, India was to be divided into two countries, that is India and Pakistan, including today's Bangladesh. It should be noted that this plan only included territories that the British government was controlling directly. Different provisions were proposed for the princely states, and provision for princely states are there were hundreds of princely states in undivided India. These princely states were proposed with an option to either join India or Pakistan, or they can choose to stay independent. Indian Independence Act of 1947 gave provisions for such options to these princely states. Many princely states immediately joined India or Pakistan, the newly formed countries. Some princely states choose to remain free. And how princely states choose countries to join means it was left on the discretion of the rulers whether they wanted to join India or Pakistan. Based on their preferences, many princely states joined India and some joined Pakistan, but there were certain exceptions, that is, states such as Junagadh, Kashmir, and Hyderabad refused to join India or Pakistan. So, integration of Junagadh, Kashmir, and Hyderabad. So let's talk about Junagadh. In case of Junagadh, which is present in Gujarat, the people wanted to join India, but the ruler was planning to join Pakistan. To resolve this, a plebiscite was held and people chose to stay in India. This is the story about Junagadh integration. And coming to Kashmir, Pakistan wanted Kashmir to be a part of its territory, and it comprised a majority Muslim population, and the ruler of Jammu and Kashmir wanted to join neither India nor Pakistan but stay independent. However, Pakistan suspected that the Hindu ruler would join India, so it attacked Kashmir and led an unprovoked invasion. To get military help from India, Raja Hari Singh signed the instrument of accession and Kashmir became an integral part of India. This is the brief story about integration of Kashmir. And coming to Hyderabad integration, the Nawab of Hyderabad refused to join India despite its people's willingness to be a part of India. During the time, Hyderabad included parts of Telangana, Karnataka, and Maharashtra. Operation Polo, it is a police action, was launched to force the Nawab of Hyderabad to sign the instrument of accession. So this is all about integration of Junagadh, Kashmir, and Hyderabad. Situation after independence. Original situation in 1950, Constitution contained a fourfold classification of states. Part A, East-while governors provinces of British India, and Part B, East-while princely states with legislature in them, and Part C considered certain East while Chief Commissioners, Provinces, and some princely states, and Part D, Andaman and Nicobar Islands. Let's try and understand what are the states and princely states come under Part A, Part B, Part C, and Part D. Part A contain Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Province, and West Bengal. And coming to Part B, Hyderabad, Jammu and Kashmir, Madhya Bharat, Mysore, Patiala, and East Punjab, Rajasthan, Saurashtra, Travancore, Cochin, and Vindhya Pradesh. And coming to Part C, Ajmer, Bhopal, Bilaspur, Cooch Behar, Coorg, Delhi, Himachal Pradesh, Kutch, Manipur, Tripura. And coming to Part D, Andaman and Nicobar Islands. So, reorganization of states after independence. Initial integration of princely states with the rest of India was purely an ad hoc arrangement. There were growing demands from different regions, particularly in South India, for reorganization of states on linguistic basis. Various commissions were established by the government to look into the demands of reorganization of states. Dhar Commission. So its objective is this commission was constituted in June 1948 to assess the feasibility of the linguistic organization of states. So it gave some recommendations. These are in December 1948, the commission submitted its report and recommended that states be reorganized on the basis of administrative convenience. And what is the outcome after this recommendation? The recommendations of the Dhar Commission created much resentment. Another committee was set up consisting of Jawaharlal Nehru, Vallabhbhai Patel, and Pattabi Sitaramaya. The committee was named after the first letters of their first names, that is, it was known as the JVP Committee. Let's talk about JVP Committee. Members present in this committee are Jawaharlal Nehru, Vallabhbhai Patel, and Pattabi Sitaramaya. And background is this committee was set up in December 1948 and submitted its report in April 1949. Recommendations it gave, like it formally rejected language as the basis for the reorganization of states. And aftermath, Potti Sriramulu, a prominent Telugu leader, was demanding Andhra state be carved out of Madras state. To get his demands met, he went on a hunger strike. However, after a prolonged hunger strike of more than 50 days, he died in December 1942. 15th, he died in December 1952, 15th December, to calm the massive uproar of the people. The first linguistic state, known as Andhra state, was created by separating Telugu speaking areas from Madras state. So, next committee is Fazal Ali Commission. What's the background of it? Let's try and understand. Creation of Andhra Pradesh intensified the demand for the creation of states on linguistic basis in other regions as well. Government was forced to re-examine the whole question. Thus, a new commission known as the Fazal Ali Commission was set up, and the Fazal Ali Commission was a three-member state reorganization commission which was set up in December 1953. Its other two members were K.M. Fanikar and H.N. Kunzru. The commission submitted its report in September 1955 and it gave some recommendations. Various recommendations given by the commission are as follows. Approved linguistic reorganization. It broadly accepted the language as a basis for the reorganization of states but rejected the theory of one language, one state and unity of India. It recommended that the unity of India should be primary consideration while drawing up these boundaries, and fourfold classification was abounded. It recommended doing away with the original fourfold classification of states and to create 16 states and 3 union territories. And scheme of reorganization is the commission recommended that the following factors should be taken into account in any scheme of reorganizing states, that are: first one, preservation and strengthening of the unity and security of the country, linguistic and cultural homogeneity, financial, economic, and administrative consideration, planning and promotion of the welfare of the people in each state as well as of the nation as a whole. And what is the outcome of it? Government accepted these recommendations with minor changes. That is, fourfold classification was abolished. States Reorganization Act 1956 and 7th Amendment Act 1956 were passed. The distinction between Part A and Part B states was done away with, and Part C states were abolished. And reorganization of states. Some of the states were merged with adjacent states, while other were designated as a union territories. The term union territory was not there in the original constitution. It was introduced by the 7th constitutional amendment. In November 1956, India was comprised of 14 states and 6 union territories. What are the states? Andhra Pradesh, Assam, Bihar, Bombay, Jammu and Kashmir, Kerala, Madhya Pradesh, Madras, Mysore, Orissa, Punjab, Rajasthan, Uttar Pradesh, and West Bengal. All these are states in November 1956. So, coming to union territories, Andaman and Nicobar, Delhi, Himachal Pradesh, Lakadivi and Minikoy and Amandivi Islands, Manipur and Tripura. And list of states and union territories created after 1956. This is the very confusion thing which we always forget. Try and understand. Maharashtra and Gujarat. So in 1960, the Bombay state was divided into Gujarati speaking Gujarat and Marathi speaking Maharashtra. Gujarat was established as the 15th state of the Indian Union, and Dadra and Nagar Haveli, it was liberated from the Portuguese in 1954. It was ruled by an administrator chosen by people till 1961. By the Constitution 10th Amendment 1961, it was converted into an union territory, is the 7th UT of India. Goa, Daman and Diu. It was liberated from Portuguese by police action in 1961 through the Constitution 12th Amendment Act 1961. Goa and Daman and Diu became union territories. In 1987, Goa was conferred statehood while Daman and Diu was made a separate union territory. So this is the 8th UT. And coming to Puducherry, the territory of Puducherry comprises Puducherry, Karaikal, Mahe and Yanam. French territory was handed over to India in 1954. It was administered as an acquired territory till 1962, after which it was converted into a union territory by the Constitution 14th Amendment Act 1962. So this is the 9th UT of India. And coming to Nagaland, initially Naga territory was a part of Assam. However, a strong movement began which was led by the hostile Naga tribes. In 1957, after an agreement was reached between Naga leaders and the Indian government, the Naga Hill region of Assam and the Tuensang Frontier Division to the northeast were brought together under a single unit directly administered by the Indian government. In 1960, it was decided that this centrally administered territory should be given statehood. State of Nagaland Act 1962 was passed, and finally Nagaland achieved statehood on 1st December 1963. So it became the 16th state of Indian Union. And coming to Haryana, Punjab and Himachal Pradesh, in 1966, Punjab was divided to create Haryana as a 17th state and the Union Territory of Chandigarh. Later demand for a separate Sikh homeland, Punjabi Suba, was raised by the Akhali Dal under the leadership of Master Thara Singh. Shah Commission was appointed, and based on its recommendation, Punjabi speaking areas were merged into Punjab, the Hindi speaking areas were merged into Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh, and Himachal Pradesh was given statehood in 1971. It became the 18th state of the Union. So Haryana is the 17th state and Himachal is the 18th state of India. And coming to Manipur, Tripura and Meghalaya, 22nd Constitutional Amendment Act 1969 created Meghalaya as an autonomous state within the state of Assam, which had its own legislature and council of ministers. But the aspirations of the people of Meghalaya were still not met. In 1972, the Union Territory of Manipur it created as a 19th state, and Tripura as a 20th state became states along with Meghalaya, that is a 21st state. Union territories of Mizoram and Arunachal Pradesh, originally Northeastern Frontier Agency, were carved out of territories of Assam. So let's talk about Sikkim. It became 22nd state of India. The 35th Constitutional Amendment Act 1974 was enacted inserting Article 2A. Now it is repealed to give Sikkim status of associate state. Though a plebiscite, Sikkim joined the Indian Union in 1975 as a full-fledged state, as a 22nd state. Mizoram, Arunachal Pradesh and Goa. Mizoram as a 23rd state, Arunachal Pradesh 24th state and Goa as a 25th state. After a peace accord in 1986 between Government of India and Mizo National Front, Mizoram became the 23rd state in 1987. Arunachal was conferred statehood as it became 24th state in 1987. Goa became a state by separating territory of Goa from UT, Union Territory of Goa, Daman and Diu, 1987. Goa became the 25th state. And coming to Chhattisgarh, it became 26th state, and Uttarakhand became 27th state, and Jharkhand became 28th state. In the year 2000, three states were created. Chhattisgarh 26th out of Madhya Pradesh, Uttarakhand 27th out of Uttar Pradesh, and Jharkhand 28th out of Bihar. So it's all about it. And coming to Telangana, it is the 29th state. State of Telangana 29th was carved out of East, while Andhra Pradesh in 2014 through Andhra Pradesh State Reorganization Act 2014. With this act, following provisions were made: Hyderabad to be capital of both the states of Andhra and Telangana for the period of 10 years. During this period, Andhra is supposed to establish its own capital. Andhra Pradesh High Court was renamed as Hyderabad High Court and would function as the High Court of both of the states till Andhra Pradesh creates its own High Court. So this is all about it. And coming to recent developments, we have to talk about Jammu and Kashmir. On 5th August 2019, President of India, while exercising his power under Clause 1 of Article 370, issued an order titled Constitution Order 2019 Application to Jammu and Kashmir. After this order, Parliament passed an act titled Jammu and Kashmir Reorganization Act 2019. This act made the following changes: Union Territory of Jammu and Kashmir and Ladakh. This act created Union Territory of Jammu and Kashmir and Ladakh. This was the first time a state had been changed into a Union Territory. And allocation of seats. Their allocation of seats. There were 6 Lok Sabha seats with the state of Jammu and Kashmir. Of these 6 seats, 5 were given to the Union Territory of Jammu and Kashmir, while 1 was allotted to Ladakh. And Legislative Assembly. Jammu and Kashmir to have a Legislative Assembly with a term of 5 years, unlike earlier term of 6 years. And coming to powers of Assembly, unlike Delhi, the Jammu and Kashmir Assembly will have power to make laws related to land, but it has not been given the power to make laws on police or public order. And under certain privileges, no more separate constitution, national anthem, or a flag like before, no more dual citizenship like before. And Article 360, financial emergency would now be applicable in the state of Jammu and Kashmir. Financial emergency has never been declared in India. And Penal Code, Indian Penal Code replaced Ranbir Penal Code of Jammu and Kashmir, and Article 35A repealed. Article 35A was made null and void due to changes in Article 370. So this is all about recent developments happened in Jammu and Kashmir. And coming to Dadra and Nagar Haveli, Daman and Diu, this is also one of the recent developments happened in 2019. In 2019, the Government of India proposed merging the two union territories into a single union territory to reduce the duplication of services and reduce the cost of administration. A bill was tabled in the Parliament. Dadra and Nagar Haveli and Daman and Diu Merger of Union Territories Bill 2019. This bill was passed and came into effect in 2020. So, what's the objective of it? This move was taken for better utilization of services of administrative officers in these union territories. And geography, Daman and Diu are situated on the southern side of Gujarat, and Daman is an enclave on Gujarat's southern coast, and Diu is an island of the southern coast of Gujarat's Kathiawar Peninsula. So, Dadra and Nagar Haveli consists of two separate parts. Dadra is surrounded by the state of Gujarat, and Nagar Haveli lies on the border of Maharashtra and Gujarat. At present, till 2023, the tally for states and union territories again stands at 28 states and 8 union territories. So, this is all about Indian union and its territories. I hope you like the video. If you like the video, please subscribe to my channel and try to close your eyes and try to listen whatever I'm saying. This method will really help you to remember all the things, to recall all the things whatever you already read, already go through so many times. So I hope you like the video. Thank you so much.